Hello, good afternoon to members of the bar and everyone joining us online. We'd like to welcome you to this afternoon's presentation, Civil Advocacy. We'd like to thank our two esteemed presenters, Mr. Ian Wilkinson, King's Counsel, and Mr. Tim Prudhoe, who's joining us from Jamaica virtually. You have been provided with their bios in the program materials for today. So without further ado, I turn you over to Mr. Ian Wilkinson, King's Counsel, who will be leading the first part of this afternoon's presentation. Thank you.
Thank you, Mr. Emmanuel. Honorable Chief Justice, Madam Justice Ajiman, Chief Justice of the Turks and Caicos Islands, colleagues at the bar, inner and outer, my friends, colleagues, ladies and gentlemen, staff of the Supreme Court, Mr. Emmanuel, of course, and everyone else. Good afternoon. As I indicated in my presentation, I would like to extend my appreciation to the Judicial Education Institute for inviting me to make this presentation. It's always an honor to share one's knowledge, and also, as I indicated in my presentation, to learn, because I'm certain that I will learn from this afternoon's proceedings already. I would like to say thank you to my learned friend, Mr. Tim Prudhoe, my co-presenter of sorts, from whom I have already learned by reading some of the material in his presentation. I would like to wish for you a very pleasant afternoon, and I hope that this presentation will be productive to you all. Now, here we go. So, this topic is of some import. I have narrowed it in some respects because it's a very wide topic, because I was told I was to speak on written submissions in civil trials. Well, I have just done a relatively simple PowerPoint presentation, which cannot capture obviously everything, because I will embellish or elucidate as we go along, and those who wish can take notes at their leisure or pleasure. But I want to emphasize from the get-go, I would say ab initio. Mr. Prudhoe doesn't want me to use Latin, but I will still say ab initio from the very beginning, that the points I'm about to make, I'm not making them in any particular order of importance, because some things which I said earlier, in some person's view, might come later, depending on their perspective. The points just need to be made. It's as simple as that. So thank you, thank you, thank you, as we move on. Mr. Emmanuel, my lengthy pauses will give you a clue as to the next slide to be put up. Right. So I'd like to start from the beginning, and it might seem trite, but what exactly are submissions? I mean, we take it for granted that people know about that which we speak, but submissions really, we as lawyers, we bandy that word about a lot. And it's interesting. I happened to speak to some law school students here in Jamaica some time ago, and a couple of them actually struggled in terms of articulating what exactly were submissions. They know these are things you say to a judge. They know these are things you write, and we're dealing with written submissions now. But it was quite curious to me that they weren't able to articulate it as well as I was hoping. So be that as it may, I went back to basics without insulting anyone's intelligence. Of course, I like, as a teacher, to go to basics. So it might seem trite, as I said, and various dictionaries have defined a submission as the act or state of accepting or yielding to a superior force or the will or authority of another person. In other words, I submit. But from our perspective, when we speak about written submissions, we're talking about, generally speaking, arguments, hopefully of a cogent, as I like to say, and meritorious nature that we put to a particular tribunal, and whether it's a judge or otherwise. In our context, we're talking about civil trials, so we're talking about a judge. And as I said in the paper, how we want to put it is we're intending to convince the tribunal in our written submissions to yield or to submit to our arguments. So I would just like to put that little spin on it, especially for the benefit of some students with whom I've had this course some time ago. Yes. So I like to start at the beginning, I said, and it's interesting. We're not dealing with criminal proceedings, no, but in some criminal proceedings, some lawyers smile when they see me walk into court with my constitution. Almost always, whenever I do a bail application, I walk with a constitution because I believe the constitution is the foundation of everything, particularly in countries which have a constitution. Now, for the purposes of our presentation, the Constitution underpins written submissions. I mean, some people might be raising an eyebrow and say, what? I never thought of that. But it is so, because your Constitution generally guarantees your right to a fair hearing or a trial. And quite often, written submissions are presented or made in the context of a hearing or a trial. And in fact, depending on a blend of your Constitution and the germane civil procedure rules, you will find provision being made for written submissions in certain cases. And of course, the legal practitioner, especially, well, everyone, particularly younger counsel at the bar who are not as au fait or experienced, really ought to be fully au fait or conversant with what your rules and, of course, your constitution say. So I wanted to take it from a slightly different perspective and to say, this is what the written submissions are underpinned by your constitution, just to go right back to basics. All right, so we can move on. Now, the emphasis, of course, is on written submission in civil trials. Now, it's a broad topic. Written submissions in a civil trial can occur at different stages, and I decided to look at it in a broader, more general way. But you can have written submissions at the onset of a trial. In fact, some practitioners feel very strongly, even though I know there's a little bit of a dispute about this, whether an opening address to a tribunal in a civil matter, say a judge sitting as judge alone, whether that involves written submissions. And some people suggest, of course they do. There's one lawyer who famously opened for, I don't remember exactly when, but I know he opened for at least a week in a matter. And he had put together a lot of authorities and he was trying to convince the tribunal from very early. So your written submissions can take different forms. You can have written submissions in a civil trial dealing an interlocutory matter. Something which might arise in the middle of a trial where a judge might not necessarily have a voir dire, but might have to take a time out to look at a particular issue which is seminal to the proceedings going forward. And therefore, you can have written submissions being done in the middle of a trial. And of course, very importantly, written submission at the end of a matter. In fact, judges more often these days prefer or love to have written submissions, and they will ask you for them in word copies and so on at the end of a trial, which hopefully will distill the matter in a very proper way and provide a foundation for them to decide on the matter in a very judicious, principled manner. So there are different written submissions which can be made in a civil trial. So because time wouldn't allow and the length of the paper would be so great, I decided I would just concentrate on making some points of general nature. Thank you. So, perspicacity. My mother of blessed memory, Miss Inez, used to speak about having insight. In fact, Jamaicans speak about wisdom. Like a good chess player, lawyers should really look ahead. And many persons indicate that even before you start your written submissions, and let's say even written submissions at the end of a matter, you ought to have a panoramic or encyclopedic view of your case. From the client retains you, from the time you get the brief, or from you have got instructions from the client and his or her version of the facts, you should be planning your closing, assuming there's going to be a trial. And that is why you have to have perspicacity, insight, looking ahead, keeping one step ahead of the opponent, for example. So I wanted to emphasize that point, that quite often you will see the experts tell you that your written submissions should not necessarily commence when the judge say you have 10 days or 7 days to do it. Your submission should commence quite often, especially for closing, before the very first word is uttered in evidence. Right. Now, when you're preparing your written submissions, there are three things that commend to you, the vital 3 R's. Research goes without saying. I try to tell my juniors or any lawyer with whom I'm appearing or associating, you never prepare an application or an affidavit before researching the law properly in relation to that matter. But they're going to look at the DLR in Canada, the CLR in Australia, the NZLR in New Zealand, Halsbury's, West Indian law reports, whatever, Jamaica law reports, you name it, CCJ judgments, you must prepare. So when doing your written submissions, research. This might seem trite, but you'd be amazed. I saw submissions recently in a matter, and not one authority was mentioned in it, in a case which cried out for authorities to be cited. And I was at shock. I was totally in shock. And I had to say, no, this cannot happen. So research is crucial. Rest. It's easier said than done, I know. But I find, and you will get me using a lot of chess analogies. I'm not going to apologize for it. But whenever I sleep night before I play a game and I get good rest, I usually do very well, even if it's against the national champion of the country. Rest. Chess players have 16 pieces each. We have a saying that rest is the 17th piece. It is such a big advantage and a game changer when you're rested. Your mind is much clearer. You think with more lucidity. So I would suggest you rest as much as you can before you prepare your submissions. You know, you will have very little time. Sometimes you have to be up burning the midnight oil, or as we say, smelling of the lamp. But you really ought to find time to rest, because quite often you will do yourself and your client a disservice and not produce the best output. Relax. This goes in tandem with resting. You need to relax as much as possible, because when you are in a state, you know, sometimes I see lawyers, especially those who come to court late. Sometimes, you know, the case is going to start at 10 and they're hurrying at 2 minutes to 10, sweating and fighting to put the papers together and all of that. No. I always tell my juniors, try and get to court early when you can, sit down, relax, gather your thoughts. It's the same thing with preparing written submissions. You need to be in a relaxed environment, avoid noises around you. You know, hopefully there's no baby crying in the background. You know, you listen to some Mozart if you prefer, or other music which might suit your fancy. You have total quiet, but rest, and relax. Thank you. Now, structure is key. Now, your written submission should have a proper structure. Now, lawyers have different styles. As I usually say, doctors differ, patients die. But regardless of your varying styles, I'd suggest the following to you. You have an introduction. When you write in your submissions to the tribunal, yes, the judge might have heard your citations or your cases or arguments in some respects before, if that judge is doing the case. But bear in mind, sometimes we're dealing with written submissions in civil trials. You might have a matter which is coming before a particular judge for the first time, or sometimes you start a trial before a particular judge, and there's a point reached in the trial where a particular thing has to be heard, and that judge can't hear it, the one who started the trial. So for whatever reason, this particular point is going to be heard by a different judge. I've seen that happen. So this judge is coming new to the matter. So judges, and sometimes I like to put myself in the judge's shoes. What would I like to hear if I were a judge? What would I like to think if I were a judge? You put before the judge the case in its nicest, barest, simplest form. Just an epitome or summary of what the case is all about early, and that comes on the introduction. State the nature of your case, state the nature of the other side's case, highlight the various issues for resolution. And when you state the case early, and I make this point later in the paper, you must indicate from early what it is the application is really about and what relief you are seeking. Don't wait till the back end to let the court know what you want from the court, what you'd like the court to do. Concentrate the court's mind or the tribunal's mind. We deal with civil trials, so we normally will be talking about the court. but sometimes you have labor disputes and so on, and quasi-judicial tribunals. You must concentrate, whether it's a single adjudicator or several persons, concentrate that tribunal's mind from early as to what it is you want. What are you begging me to do for you, etc., etc. State the facts, particularly where they're indisputable. Sometimes there are facts which are in dispute, but you have to state your version of the facts, and you state it in as compelling a way as possible. All right, and you have to cite the relevant law, and then you cite the law. You have to be. I don't necessarily like to cite 10 cases for the same point. What I like to do is to cite the locus classicus. You know, Donoghue and Stevenson is well known from 1923, even though it was not necessarily the first case on negligence, but it is accepted as a locus classicus. So you know, in criminal proceedings, people like to cite McNaughton's rule, McNaughton's case for insanity and so on. You cite the locus classicus if you can. And I always find it's useful to cite a more recent decision as well on the point. And in addition to citing a more recent decision, you cite a decision which is from a very strong court. And there, as I said, doctors differ, patients die, there are different courts. You always try to find a decision from a very good court or judge. So there are some judges, when you see their judgments, you cringe because some of the judgments are very bad. And lawyers joke and say the first ground of appeal is just to cite the judge's name. You know, there was a particular judge in Jamaica who used to sit, and they would just say the first ground of appeal is to put that judge's name. That was just a joke at the bar. But cite a powerful judge, like when you cite in cases with people like Lord Diplock, people like Chief Justice Wooding and those folks, well-respected judges. And after you apply the law to your facts, you present your conclusion as forcefully as possible. What I've just had here from points 1 to 8, in essence, capture written submissions in civil trials. It is just about developing now. Now, I put this picture up. Many of you might know what that is. I don't know. I'm not necessarily dating myself, but the sci-fi junkies would realize that is the Starship Enterprise. Sometimes you have to write written submissions on a very novel or delicate area of law. The Starship Enterprise, if you follow the old series or not, will tell you you're going to places where no one has been before. You need to look at your submissions very carefully. Be almost fastidious, hard to please. Be your own demanding driver, you know, your own demanding taskmaster, and subject your submissions to piercing light of scrutiny, particularly if a novel area of the law involved, because you're taking the judge into virgin territory. You're taking the judge into an area where he or she might never have been. And you're going to be an important part of creating a precedent or law. So that is one of the reasons I wanted to share a Star Trek thing with you. Look at the Enterprise, fascinating. Now, written submissions. Written submissions are a fantastic platform on which to persuade tribunal. You know, first thing first, many love to see a great, brilliant advocate who has the gift of gab, as the Irish would say, who some might say might have kissed the blandest stone. Some advocates don't kiss the blandest stone, they actually eat a piece of it. So you love to see and hear that person on his or her feet. And one such was like the late, great Honorable Ian MacDonald Ramsey from Jamaica, who when he was in his flight in the 60s and the 70s, for example, people come to court just to watch him, just to see him, all of that. But be that as it may, while advocacy and oral submissions can be endearing and engaging, in my humble view, and I think many persons share this view, there is a lot to be said for written submissions. Because you see, quite often, you don't have a lot of time to prepare your oral submission, even though similar to written submissions, you should be thinking ahead from when you get the case. And quite often with oral submissions, you have to, as they put it, wing it, because sometimes the tribunal might throw out a question at you on your feet, and you might not have the right riposte. You might not have the right response. It is the written submissions, even if you have a very limited time, 3 days, 1 week, or so on, at least you have some time within which you can have sober reflection, structure your arguments, prepare, organize, and so on. So I find that preparing written submissions is quite useful, and you're able to craft and mold and develop your points or arguments and structure your written document as how best it should be. Yes. Now, what are your written submissions, really? Whether it's dealing with an interlocutory matter or you're dealing with closing, you're basically telling a kind of story. And it is up to you to narrate that story effectively. No, you're not speaking. We're talking about written presentation, but it can still be very engaging. You're not on your feet, where you're making eye contact with the court, where you're using gestures, where body language and so on is important. But all of that can be conveyed in the written document. Tell your client's story effectively. Now, how you tell it is another matter. There are some lawyers who say, don't use certain words. I mean, some of this, what I'm saying to you, you will not see on the PowerPoint because space doesn't allow for it. But of course, your story should be as concise or succinct as possible. As I was saying to my learned friend, Mr. Prudhoe, recently, I like short paragraphs. I don't like my paragraphs to be more than 4 to 6 lines. I have seen paragraphs taking up almost an entire page. You know, just always think if you're the judge and reading this. You know, the worst thing a judge like to see with written submissions is like volume of Halsbury's coming at him or her. Yeah, I tell my juniors, try and make your submissions as short as possible. My starting point is your submissions must not pass 10 pages. Don't pass 10 pages. Try and keep single digits, 9 pages if possible. Of course, that depends on the nature of the case. All right. But whatever you do, regardless of the length, you must tell a story, and you must tell a captivating story, and bear in mind the tribunal. So whether you're going, I don't think there's a problem using Latin. You use whatever tools captures the imagination. Like I saw my learned friend, Mr. Prudhoe, I don't know if he'll use it in his presentation coming up, but he referred to one of my favorite French expressions, noblesse oblige. Responsibility comes with rank. That's one interpretation of that French expression. That's French. He's using it. So if you can use French, why not Latin? For me, it's not about Latin, English, French, or whatever. It is about what tool is the most effective, convince the tribunal using this written forum. So I just wanted to emphasize that you need to know your judge. Some judges love to hear the Latin and they will rattle it off. And when I say the use of Latin, I'm not suggesting you're going to be talking to the judge in Latin or confusing the tribunal. Falsa demonstratio non nocet cum decopode cons, not that long thing. Sometimes it's just simple little thing was my client, this witness was clearly compos mentis. Common expressions. The Latin is all pervasive, inter alia, bona fide. It's all over. Can't avoid it. But the point is, what is the most effective tool which we should use to convince a tribunal? All right, good. Weave a proper web. This is aligned to the earlier point about your story. Your written submission to be properly woven, bearing in mind, especially if it's being presented at the end. You pull all the constituent parts together, whether they are from evidence in chief, cross-examination, re-examination of any particular witnesses, as we'll deal with a little later down, whether you're looking at exhibits, whether you're dealing with a particular bit of evidence, a particular juncture, whether, you know, it is how you structure the matter. But whatever you do, as part of the earlier 8 points I listed in the introduction, state nature of the case, and so on, you weave a web. The French have, speaking of French earlier, the French have an expression I learned in high school, which they normally deal with plays. You know, Shakespeare was famous for it. They have a denouement, which is their fancy word for the complex unwinding, the unwinding or the resolution of a complex plot. At the end of the day, a whodunit, you figure out who did this in Agatha Christie style. This is what you do when you're presenting your written submissions. You organize it and you weave it in such a way that it sets out almost like it's a novel, but it's not fiction, but you set it out in an engaging way using the words as simply as possible. Start with a bang. Listen, it's in writing, but you have to start with a bang. Get the court's attention immediately. Grab on it as if you're riding a bronco. I always like to watch those cowboys riding that bronco, when the bull is, especially when the horse is going to catch them, or bull sometimes, which they do. Never let it go. Engage your judge. Capture the tribunal's attention from the get-go. Those first few lines of your submissions, even if you use a fancy quotation, even if you quote the judge, him or herself. I always like to quote judges to themselves. It's hard for a judge to resist that, especially if you're quoting from an earlier case from a judge, from that particular judge, and that's No, this is important. Be tidy. Your presentation is key. I have seen, so even, yes, we're speaking about written submissions and content, but appearance is important. I've seen written presentations in such an untidy style. So first thing, your written submission should be properly bound. They should be properly indexed, especially if they're thick. They should be properly numbered. They should be properly lettered, properly tabbed. Whether you tab them with colored tabs or so on and so forth, your submission should be presented. Proofread. I tell my staff, don't send an email unless you read it 3 times. I would say the same thing for written submissions. Read it 3, 4 times. Go over it till you're weak. You might be tired, but as I say, sleep on it and come back the next day with fresher eyes if you can. Or you don't have the benefit of the next day, rest your eyes for even 30 minutes and then look at the material again. So you must avoid typographical errors. These things turn off a judge and judges think that you're sloppy. And simple as it is, judges might not even accept your case. They might say, listen, this lawyer is a joker. I really can't believe what he said if he's making all these silly mistakes. So cite your cases and authorities properly in your written submissions. Number your paragraphs, have headings. If there are 6 major issues before the court, a judge doesn't like to see when the submission is written in such a way that is just one long stream of writing coming at him or her. You must put your little headings. Hearsay evidence. You're going to make submissions on what was hearsay evidence. Put a little heading, hearsay evidence. Lack of credibility. You're going to challenge the witness's credibility. Have a little heading, lack of credibility. That kind of thing. Poor exhibits. You're going to treat with exhibits. Put a little heading, deal with exhibits. That kind of thing. Number your paragraphs. And you can number your pages as well. So I wanted to bear that in mind very, very carefully. All right. It is Mr. Emmanuel. I want to, in the first instance, I plan to speak for 30 minutes, so you can let me know when I'm at that junction. I like to pause so Mr. Prudhoe can start. But before I pause and you will give me my cue, the next point is when in your written submissions, you have to face the difficulties head on. Sometimes your opponent has such a powerful point, a very strong point. Can't put your head in the sand like an ostrich and hope that it will go over the judge or that it will just disappear miraculously. Poof, Houdini-like style. No, not gonna happen. Face it head on. Especially if you have a good refutation. You can decide when to face it. Sometimes it's better you face it early so that if it's a really good point and your refutation is not that powerful, but it's a 50-50 whether the judge goes one way or the other, you don't want to do that at the end of your closing, especially if you're doing written submissions. You don't, so that is one of the last things the judge has in his or her mind. Deal with it from very early. All right? If it's not your strongest point, get it out of the way from early and concentrate on your strongest points. Okay? In your presentation, I touched on this with the introduction earlier when I listed the 8 points which should form the part of the written submissions. It's a habit I've developed, and I smiled when the late great, I might say, Justice Dennis Morrison. I miss that man so much already. We spoke about the structure in presenting submissions in the Court of Appeal many years ago. In fact, when Mr. Justice Panton was the president of Jamaica Court of Appeal. And the structure I suggested, we discussed, it's almost routine, and I'm not saying I was the one who made it routine or it was solely from me, but one of the things we discussed from early, in the very first couple of paragraphs of your submissions, court or tribunal must know what you want. If you have a 10-page document, don't save it for the 9th page or the 10th page. It should be on the first page. If not the first page, the 2nd page. Very early, tribunal should know, why are you writing these submissions and what do you want from me? So I wanted to emphasize that from early. Be frank with the court in your written submissions. The great Einstein said it. If you're careless with the truth in small matters, how can you be trusted with important matters? You must engage the court in a very frank and forthright manner. Now, if your opponent has a good point, concede it in the written submission, but concede it in such a way that it is not necessarily inimical to your client's case. You concede it in a fashion which will allow you to rebound from any, or your client from any damage it might do or have done. You know, and that is why the timing, the strategic place where you put it is very important. Good. I like to, you know, I'm not Aretha, so I can't R-E-S-P-E-C-T, but respect. When you're doing your written submissions, you know, and it's a written document we're talking about, written. Yeah, document is written, yes. But you can still convey the respect you have. The lawyers who disrespect the tribunal in writing, and I've seen some submissions, you'd be amazed at the language that counsel use. And I have to say to counsel, but counsel, this is not your case, and it's a client's case, and you risk offending the judge. You know, the experts tell you, don't impose your opinion too much on the court. It's not about your opinion. Yes, it is your opinion, and you want the court to agree with what you're saying. But it's really your client speaking to the judge. So you must use amiable language, felicitous language, cordial language as much as you can, even in relation to your opponent. I've seen written submissions attacking opponent submissions. I will do it, but in a very sanitized way. But you don't use very derogatory and disparaging remarks, especially in your written submissions. Treat the court with respect, treat your written submissions with respect, and it gets you quite a bit of favor. So I think this is a point at which I can pause. I shall be back to wrap up a little later. And we're going to be tag teaming. And I now cede the floor. Thank you, Mr. Emmanuel, to my learned and illustrious friend, Mr. Tim Prudhoe.
I think we're going to put my slides up. I'm going to stay standing if that's okay. Give us a second. Wonderful, thank you. Protocol having been established, I would just like to thank those responsible for me having the opportunity to address you and also to co-present with such convincing leading counsel. It's a great pleasure to be dealing with Mr. Wilkinson. In terms of his comment a few minutes ago about facing trouble head on, I think this is especially important in the context of civil advocacy and written civil advocacy, because the likelihood is, particularly in a jurisdiction with a low number of civil judges, is that there's going to be a delay. There's going to be a reserved decision, and you're going to need to have provided convincing written material for however many months down the line what you've said is being considered. I'll also come on to whether or not I agree with whether 10 pages is always enough. It really depends on where you think your case is headed and what your prospects are of being decided at first instance in a way that won't lead to an appeal. So could I have the next slide, please? The whole subject involves a great deal of effort. I'm sure leading counsel will agree. Although not everybody is born a natural, hard work can certainly make you significantly better. And Thomas Edison, who invented the light bulb, rightly said, genius is 1% inspiration and 99% perspiration. That's exactly the same situation in relation to written work or written advocacy. And you need to hunt out the cases in which you can practice that. And that may very well mean in the early stages of your career, you need to hunt down colleagues who have an appetite for those cases and either ride on his or her coattails or actually encourage them to take a case that ordinarily you wouldn't be entrusted with. And a characteristic of my practice in this country, at least, is to hunt down those cases in the last at least 4 years. And it provides long-suffering colleagues like Miss Lockhart over there the opportunity to work on cases where nobody has any idea what the law is as it relates to Turks and Caicos. Not that they don't have a clear idea, it's just nobody knows. And unless you have an appetite constantly to be testing yourself in that way, you're selling yourself short in the sense that you're never going to improve to the maximum extent. If you have been on TCI Lee recently, the case that just got posted yesterday is a pretty good example. The same-sex marriage, the constitutional case, well, leading counsel says take your constitution to court. Well, we did that in a rather different way in that case. But again, although there were cases in other overseas territories that gave us a steer as to what would happen, of the very nature of what we were doing was a complete launching into the unknown. Similarly with the island status judicial reviews. None of these are to advertise my firm, but to give you a flavor of the fact that you need to hunt down innovative work, really to prove what you can do on paper. And in those sorts of cases, I think, with respect to leading counsel's comments about 10 pages always being enough, you're going to have to expect that some more work is going to have to go onto paper, because the likelihood is that these sorts of cases are going to end up on appeal. And I come back to the way that you should, as it were, custody your material or house your material, because judges ask for it. We've happened to have the chance to do things similar in St. Kitts on a passport revocation for economic citizenship. Again, never been done. And judicially reviewing regulatory fines in Nevis, in the Federation there. Again, never been done. Just this morning, at 7 a.m. Turks time, on the Privy Council website, there is a case of mine that got posted. And it's a very good example of the effect of a strong skeleton argument. A bit too successful in a sense, because I wasn't actually asked to say anything responding to the appeal. But the point is, as a result of my skeleton argument, the Privy Council heard a preliminary point and dismissed the appeal without hearing the substance of the appeal. So, and if you wanted to go onto the website of the Privy Council, you'll find it, the Darren Singh case, and it discusses what happened. And that's a demonstration, a real-time example of what a good skeleton argument can do. I did rather sell myself out of the hearing, but it was certainly quite satisfying. And the reason that we opened an office in Guyana is much for the same reason, because we can pick the sorts of cases that we would never get our hands on anywhere else and roll those out and test our skills. My aim as perhaps a more aged lawyer is to infuse my colleagues who are younger into the game so that the system of people who will test the law perpetuates itself. Now, to my French, I prefer French to Latin. I think Latin makes lawyers sound outdated and sort of clinging on to tradition. Noblesse oblige is a phrase which I think sums up the responsibilities that good lawyers hold. They have incredible responsibilities, incredible honor to be doing what we do. But with that comes an obligation. And an obligation is to own the need to persuade a court. Almost by definition, the person sitting in front of you has become a judge because he or she is good at the law. That's not the same thing as you going to persuade them and, in essence, help them come to the right decision. But there's a great clarity of purpose in being the person who's going to have to stand on your own 2 feet to justify what you've put on paper. And in the same way that a leader in Mr. Wilkinson's position, I wouldn't say beasts, because I'm sure he's much nicer than that, but pushes his juniors towards excellence, you have to do it to yourselves. And I'm going to give you a very short example in relation to someone called Henry Kissinger. I appreciate you're lucky enough to be a lot younger than me, but he is considered generally to be the most talented American who never became president. And the reason, without getting into a US constitutional issue, is you're not eligible to be the president if you're a naturalized American. And he was, I think, Hungarian from Europe. Anyway, he had a variety of speechwriters because he had on his plate at the time the following foreign policy issues, because he was the Secretary for State at the time. Had the opening up of China, the closing down of the Vietnam War, and the attempt to improve relations with Russia. And he asked his speechwriter to write a speech on one of those. So Kissinger tells his speechwriter to prepare the first draft of the speech. Kissinger then calls the speechwriter, who's called Lord, the next morning and asks about the speech. Is that the best? Is that really the best that you can do? Lord's obviously a brainiac. He'll be Harvard, he'll be Yale, he could be both. And he said, well, I thought so, but I'll have another go. Starts again, revises it, resubmits it, and provides a draft to Kissinger a couple of days later. Kissinger again calls Lord and said, are you sure that that is the best you can do? And Lord's obviously a very talented person, starts to question his own sanity and says, well, yes, I thought so. I'll try again. Anyway, this happens a total of 8 times before Lord loses his temper and says, yes, that's the best I can do. So Kissinger says, well, I guess I'll start to read it then. The point is, he pushed the guy to improve each time without even having to review the document. And you need, at that level of discipline, irrespective of whether you have the dubious honor of working with more senior colleagues or working on your own. And in case anyone is in any doubt as to my view, if ever there was a reason to work with people senior to you, it is to improve your written work. Because although you can go to court and watch people who you don't work with perform, and that's hugely beneficial, much more limited opportunity to do that with written work. So in relation to delegation, if you do work with others, there are problems and pitfalls that you need to be ready to navigate. I have been guilty, as I'm sure others who have been doing this job for a long time, of leaving too much to less senior people and realizing on your feet that either you're not fully able to understand what they've written, or sometimes both, you understand what they've written, but you don't agree with it. Not a great time to figure that out when you're having to justify what you're saying. But the problem is in the reverse too. If you're in a situation that's supportive enough to have more senior people try and improve your work, but to leave that work with you, and let's hope you have access to those sorts of people, don't just think, well, because Mr. Senior Person has said that this is the position, that you don't have to digest it and be able to understand it sufficiently to be able to explain it yourself. It's a disaster if you're asked by a judge to explain something and you realize it's somebody else's handiwork. Next slide, please. There are definitely places that don't call for written advocacy, and people get this confused on a surprisingly regular basis. Witness statements are not a way to argue your case. So I suppose it's the reverse of a skeleton argument. Witness statements are supposed to be an opportunity for a clean explanation of what happened from the person who saw or read it happening, watched it happening. And if you wanted 2 of the best known examples, one is an English one about the need for witness statements to cover actual events known to that person. And there was recently one in the BVI commercial court, which pulled those cases all together. The second one of those is a transcript, which I have, if anybody either watching or attending wants to see that. It's a very useful reminder, and watch out for the changes to our civil procedure ordinance. Expect them to say something about the way in which witness statements are formulated, because there has been a significant amount of change in the English law. For those of you who've had the chance to spend any time practicing in England, much, much stricter about the way that you compile witness statements, and quite rightly so. You can see and smell argument in a witness statement from a very long way off, and it damages the credibility of the case that you're trying to run. So in exactly the same way that Mr. Wilkinson said typos hurt you, so do witness statements that have clearly been drafted and used as mouthpieces by lawyers. Can I have the next slide, please? Help the judge. Really no different to what Mr. Wilkinson is saying. The court is the entity to whom, and therefore by extension the judge, the person to whom you owe your paramount duty. And tempting as it may be to bury a case that's extremely unhelpful to you, piece of case law, you have absolutely no doubt about the obligation to produce it, and you will get killed, at least in the Court of Appeal, if you have done anything that could be construed as trying to hide that piece of case law from you. In reserved decision scenarios, so judgments that come out weeks later, quite often the judge will have gone off and done his or her own additional legal research, and woe betide the advocate. He was hidden, the locus classicus, as Mr. Wilkinson would say, or the governing case from that judge. If you have a deadline for a skeleton argument, hit it. I know that sounds so basic, you wonder, well, why have I just driven down the Leeward Highway to listen to that? Time and time again, a good skeleton argument from an opponent of mine has arrived sometimes only minutes before the hearing and doesn't get read. It's almost like that person is trying to help my side of the case by screwing it up. So even if it's only a B+, and you think with an extra night of work on it, it becomes an A, get the thing in as close to the deadline as you can. And you need bundles, and all of the issues that Mr. Wilkinson raises, I agree with. It doesn't have there's no prescribed way to tab bundles and divide documents, but they are the nuts and bolts that hold a skeleton argument together. And without those, you're really doing yourself a disservice. Next slide, please. If you've put a skeleton argument in on deadline, there's a good chance that the hearing bundle and the authorities bundle don't exist. So, without changing any other content of your skeleton argument, when the hearing bundles and authorities bundles have gone in, do yourself a favor, because you're going to have to do it anyway for your oral submissions, but more importantly, do the court a favor by going back to your skeleton argument, which is carefully preserved in a Word version you can identify as having been the last version, and cross-reference it. Sounds very basic, but it is amazing how often that is not done. Keep a Word, final format Word version. Why? Because you would be surprised, particularly as you get further into this game, how often judges want your skeleton arguments in Word. Why do they want it in Word? Well, you have to tell yourself that your skeleton argument was full of such genius that it's going to be reproduced in their judgment. But even if it's going to be only rubbished in their judgment, if you can help the judge, you may save time in the wait to get the judgment, and you may, in fact, get in that judge's good books. If you're able to, and you feel that you have enough experience to be able to do so, indicate that this application that you're making is worth 45 minutes of reading, or whatever it might be. And if you're feeling really on top of your materials, and there are a lot of materials, indicate the 2 or 3 documents that they need to read. Don't make it too small. I think the official minimum is 11 font, but I wouldn't write lower than 12 font. I wouldn't make it closer together than 1.5 spacing, but several people prefer 2. And you need margins and you need headings for all of the reasons that Mr. Wilkinson suggested. I fully agree with him. Latin or no Latin, short sentences, numbered paragraphs, as few subordinate clauses as you can, because the longer a sentence, the more difficult it is to understand. And make sure, particularly if people are sharing a skeleton argument, so people are taking parts of the skeleton argument to do, and then someone is responsible for fitting it back together, make sure at the end of that process that there is consistency in style, abbreviations, and spelling. Doesn't really matter if you prefer American English in Word over English, but have the document keep the same approach all the way through. Next slide, please. This was said to me recently by a judge. It was said to me when I was on my feet, but it was also said by the same judge about my skeleton argument. And praise to that judge for telling it like it is. And he was, and I'm sure still is, right. So always figure out whether you can say what you're trying to say more briefly. Really as simple as that. Try and avoid jargon. You may one day, not every day, have a client sitting behind you. So in just the same way that if you're sending an update to a client, you'd leave out any legalese. Try and make the hearing as understandable to the client as possible. I wouldn't say, perhaps my colleagues would disagree, I wouldn't say I'm phobic about Latin, but I would certainly need a good explanation as to why Latin was needed. I agree with Mr. Wilkinson about the need to focus on, well, whether you call it the seminal case or the most recent confirmation of the seminal case. A little tip for someone who's not originally from the region, always work backwards. If you find an English case, try and find it again, the same issue again in the West Indian reports or the law reports of the Commonwealth. The first time I appeared in front of the late, great Edward Zacher, he leant over from where he was sitting in the Court of Appeal and said, I say this nicely once to new lawyers, to the region. We have our own law reports, because obviously he was trying to tell me that I was too dependent on the English reports. That's just a version of knowing your judge. 100% right that some of the judges that you will appear before in the Court of Appeal will have either been very senior government lawyers. So Sir Elliot Motley, for example, was the DPP in Bermuda, but has also sat in many other places in appellate capacity. So I think he sat in at least Belize and Cayman. Edward Zacher did the same thing. If you can find a decision of theirs that will help you make your point, they're only human after all. I suggest that you do it. And what I always do with my colleagues who are working with me on a case is have them try and scour the law reports for a Caribbean or at least non-English version of the point that I'm trying to make. Would you? Thank you. Simple. As simple as you can possibly explain, as simply as you can possibly explain the point that you're trying to make. Good afternoon. And this slide has an extract from a case that's part of a fairly chaotic series of cases in Montserrat, which many of you will know is not very far away from Antigua and St. Kitts. Depending on how you count, there are either 42 or 46 overlapping cases. And in the years that I've done this job, I've never come across a more complicated factual matrix in terms of the sheer amount of litigation. Trying to explain to a judge in a glorified strikeout application the significance of the 40 plus cases was extremely challenging because the essence of the explanation is itself complicated. So there is the phrase I came up with. an attempt to put lipstick on a pig, which for those of you who don't know the sort of idiomatic English, it's just a hopeless attempt to make something look good. And look at his detailed analysis in the next sentence. I agree. So if you can abbreviate the process, and you get a sense from the rest of that paragraph how hideously complex the litigation has become, but if you get a way in to make the explanation accessible, I suggest that you try and seize that. There is a very effective polemic, he describes it, but anybody who is available on Saturday should come to see the criminal advocacy, because that judge, Ian Morley, an English lawyer who's now based in St. Kitts, has written The Devil's Advocate. And in The Devil's Advocate, he explains in the piece that I've extracted there and quoted at the bottom of that page, what you should try and avoid making your written submissions look like. The less dense and impenetrable, the better. You can read it for yourself. I think the sentence with the vibrancy of an instruction manual for a car alarm is a particularly nice way of putting it. Because relatively few judges will actually put you right. A lot of judges tend to endure what you have got to say. Next slide, please. Thank you. It's important, particularly if you're junior, not to treat a skeleton argument as a script. Why is it particularly important? Well, first of all, you look wooden delivering it. And secondly, you are thrown more than any advocate is thrown if you're asked a question, because you start to panic about wanting to get back to your script. There is a basic anatomy of a skeleton argument. Mine varies slightly to that of Mr. Wilkinson's, but it's essentially the same thing. My second bullet point is his Starship Enterprise point. If the law is not yet established, say that. Have the judge become sufficiently confident in what you've got to say. Have him or her become confident in making the law not so much with you, but for you. And where Mr. Wilkinson describes his denouement, I would say solution. So you have to get to somewhere quickly in the document to make it clear what the outcome is that you say should be granted. Now, some people lead with it. I once went to a session like this run by then, he wasn't a Lord of Appeal, or Supreme Court Justice as they became, Lord Sumption, when he was still simply Jonathan Sumption, said, oh, make all of the beginnings of your skeleton arguments exciting. Well, maybe if you're Jonathan Sumption, you can do that. I realize a strikeout application or a summary judgment application is not always something that feels especially exciting, extremely difficult to make it sound exciting. But if you can say, of the 75 pages that the judge has got to read, this all turns on 3 pages of materials, you can at least, if not make it sound exciting, you can make it sound digestible. I think you have to be very careful with the way that you plan your closing, and you have to be very, it's fine to have it as a way of framing what you're aiming towards. But if you over open, so if you explain to the court what you're going to be able to prove, and then you don't come up to proof, there aren't many opponents who aren't going to jump on that. So have it as a plan, but don't necessarily have it as a declared plan. And perhaps Mr. Wilkinson will have a view on that. I'll just scoot through the last pieces of what I have got to say. Often in written arguments or the directions for written arguments, somebody is given an opportunity to reply. It's a bit unnerving when your opponent doesn't bother with a reply, because you think, God, was my skeleton really so bad that he didn't feel he had anything to reply to? That's exactly what happened in the same-sex marriage case. The Silk from Blackstone didn't reply to our skeleton argument. So we're all left wondering whether that was us or him. Mr. Wilkinson has dealt with written closings and will deal, I'm sure, with post-hearing submissions. However irksome it is, irrespective of whether or not you're on a flat fee with your client, If you're given the opportunity to do this, do it. There'll always be something that you have missed or that someone with you in court has picked up and you have failed to. So go the extra mile. Not really the skeleton argument issue, but as you grow in confidence and as a judge is either shaking his or her head energetically or nodding to you, say that for the purposes of the transcript. So as you're delivering your submissions and they're looking like they're going to attack you or they're gurning at you, say, I see that the court doesn't find favor with that, and I'd like to explain X or Y. For one thing, a judge who's looking so visibly against you sometimes sort of straightens out and gives you a little bit more to say. And for another, if you do end up going to the Court of Appeal, you have a clearer idea of how things were going. Not a skeleton argument, but a very important piece of material. If you do an ex parte or without notice hearing, you definitely need a note of hearing. And then, can I just have the, thank you. I have here, and it was a very useful exercise having to prepare to talk to folk who I had assumed were the perhaps less senior end of their careers. Very interesting revisiting the materials and seeing what's out there. This document, this text, Pleadings Without Tears, has a section on skeleton arguments. This has been in print so long that I used it at bar school. I would thoroughly recommend it. So if you want to get the ISBN number from that, take that. The bar manual in the UK now is a standardized one. There is a section on that, not only about skeleton arguments, but about the length of skeleton arguments. And Mr. Wilkinson will be delighted to hear that it does say you should stick to no more than 10 pages, often below that. I think that works in relatively run-of-the-mill cases. It's more of a problem. And I'd be interested to hear if he disagreed. More of a problem, I would suggest, in cases where you are leading the court by the hand. So to apply that to some of my cases, in the habeas corpus cases for the Sri Lankans, I had to spend several pages explaining the concept of habeas corpus in relation to an immigration detainee. And there's no way I could have got that through that in only 10 pages. Next, to aim for. I'm just going to read these out so that people aren't having to, we're now a long way into the presentations. Legal writing should be like a cavalry charge. Swift, full, impressive, with no messing around. It should cover the ground, all of it, and do the job fast. Legal writing is not the military equivalent of the trenches of World War I, endless, uncertain, and bogged down. Again, Ian Morley out of this. And finally, a quotation from him. The judge needs to be helped to shore, not drowned in paper. The hallmarks of an able lawyer, and you've certainly heard from one in the form of Mr. Wilkinson, being able to distill large amounts of material to what is needed and being right. This is absolutely crucial, being right about what is irrelevant. And then finally, a plug for somebody who I would say is really my advocate idol. Anybody who can find a podcast will be able to find several interviewing someone called David Panic. And I'm sure he's sick of being told that it's rather ironic what his surname is, because if you want to see someone totally a master of his craft and totally at ease in what he's doing, I'm sure you'll be able to find it on YouTube. Watch him present, for example, the case of Gina Miller on the Brexit litigation in the House of Lords. Absolutely unbelievable. And he is interviewed really all over the internet. You can find his interviews, and he talks about his skeleton arguments and his advocacy. I wouldn't believe that would be time wasted. I also have a couple of other texts if you want to take the details of those, all of which attest to the fact that although there is a degree of individuality about the way you present skeleton arguments, a lot of it can be learned. Thank you. Have we lost Mr. Morley? Not Mr. Morley, Mr. Wilkinson.
Thank you very much, Mr. Prudhoe. Mr. Wilkinson, Casey, we now hand back over to you.
Thank you. Thank you very much. I'm still very much here listening to every word. And I'd just like to congratulate Mr. Prudhoe on an excellent presentation, quite thought-provoking in a number of respects. I will soon be through. I'm actually at slide 19 of, I think it's 25. So I won't engage the audience for much longer. But I'd just like to make a couple of remarks or reposts in relation to what my learned friend has said. I'm not hard and fast on the Latin. I am one of those, I do not believe it's dead as some people think. It's very much alive and well, and it is the root of a lot of the current language. In fact, it's used so often in our daily speech. That is one of the points I've tried to make time and again. It's not my favorite of the old languages. J'aime beaucoup la langue. I love French. C'est très, très joli. It's a beautiful language. I just a quick anecdote. This book, you'll see the title, Lawyer's Latin, Evade Mecum. It is now one of my treasured possessions. The late Justice Morrison and I used to have some discussions. In fact, in his early days, I used to call him linguist. And we used to speak a lot about Latin. Most of my appeals, I'll tell them that the fons et origo, the genesis or the origin of this matter, it's a matter of style. I mean, you have to know your court. There are some judges before whom I appear, I will never use an ounce of Latin. Some judges like it, and they will rattle it back at you. And it's all a point, but that is oral presentation. But sometimes it works in writing too, depending on the judge, especially if you learn that the judge was #1 in Latin in high school back in the 1960s. You have to know your court as well. So it's a matter of what do I use to get as much advantage as possible from my client? Because you have to embrace the judge. You have it at the end of the day, you are presenting something in writing, but you can still embrace the judge. You have to let the judge like you without sucking up to the judge unduly or in a very obsequious manner. Because sometimes decisions are 50-50. And believe me, if the judge likes you more than the other lawyer, you can guess who's going to get that decision. You know, because I have sat as a judge in some tribunals, especially in state of emergency courts. And there's times when you're really uncertain whether you go left or right. And it's just that little indecipherable, that factor, which will determine it. So this book from the late Justice Morrison, in time will be selling for probably £1 million. I know Mr. Prudhoe will be one of the highest bidders. But let me continue. In relation to the 10-page limit, as you quoted from the English provision, I honestly was not aware of that. That 10-page just came to me generally because I found that the longer submissions are, the harder it is to wade through them. And quite often, I found that cases which involve thousands of pages can usually, the issue is usually in 1 or 2 paragraphs. It's just amazing. Recently, I was involved in the leading case right now in Jamaica dealing with an attempt to repeal the Buggery law, the Tomlinson case, which is headed on appeal. And the submissions we filed in that case, they numbered 53 pages. So my 10-page rule is just a guide. I'm aware, depending on the complexity of the matter, it's not likely to happen. So let me move on. Closing written submission. I had actually cited Justice Morley's book, which was brought to my attention some time ago by someone, but it's from the third edition, and where it refers to the closing speech. But of course, this can be taken in the context of a trial, but I'm looking at close in the context of written submissions. All right, it says it's a weapon, their art. It is a moment for persuasion. Some say the advocate's greatest weapon is cross-examination. Not so. A good speech can recover bad cross-examination, but a weak speech can lose an otherwise unwinnable case, even after a good cross-examination, especially if your opponent makes a much better closing speech. In other words, beware the closing speech, master it or fail. In other words, what Justice Morley is saying, listen, this is a last shot at redemption quite often, your closing speech. Is what I call on the next page, your last parados, an expression we use to mean this is the last chance, the last grab, as some would say, last chance saloon. it is your last chance, and I'm talking about written submissions in the context of closing now, to make a big impression on the tribunal. You know, this is especially so if there will not be a chance to elucidate or embellish via oral submission. Sometimes you present written submissions and you have a very narrow window where the court will say, listen, I will see you in court on X date, and you will have 20 minutes to speak on any salient points or to address any questions which I might have. That kind of thing. In fact, I didn't put it in this paper, but one of the techniques some lawyers use is to include in their written submissions a sentence or line which says the client reserves the right, or the first defendant, the respondent, whomever, reserves the right to make further submissions on a particular point, subject to what the other party might say. And it goes back to what Tim said in relation to a reply and so on and so forth. During the case, often you should be taking notes. In fact, you know, we just finished that particular trial in the Turks, and for a couple of years, I would take notes at regular intervals. And I said to my juniors, make a note of that, make a note of that, highlight it. I have a habit quite often. You can't do it normally in written submissions, but I have a habit of working with several different color pens. Some things are more highlighted. Some things get the red ink treatment, some get the green ink, some get the blue ink, depending on the level of importance. When you're finalizing your written submissions, you have to consult those notes because they are of truly seminal importance, and they help to concentrate your mind in a certain way. And the longer the trial, the more you're likely to forget certain things. They might recede, and they're very important. Is when you're looking, you say, it's like a eureka moment. And you said, but this is priceless stuff. I have to use this. Now, what I want to pause here, at the end of this slide, I tell you that before you finalize your submissions, and Tim referred to some of this, a junior, I find, is essential. Now, that junior might obviously not have your capacity or experience, but you might be surprised. Sometimes some juniors know the facts even better than you, because they might be the ones who have been taking more notes. Where possible, enlist the service of someone to help with your written submissions. A different pair of eyes who can give a different perspective. They say two heads are usually better than one. Of course, you have the casting vote, you'll have the final say, but I think it is salutary to the client to have this opportunity. And where you appear as senior, whether silk or otherwise, it is always useful to have a junior. Not to do the donkey work, but to have meaningful discourse. Now, I told you must open your written submissions with a bang. Whether you're going to quote Shakespeare, or whether you're going to quote one of the new singers or the new rappers, or you're going to get something from Burna Boy or some Afrobeat person, doesn't matter. You open and you get the court's attention and you hold on to it for dear life. But this is where you close. In your written submissions, although you're starting impressively, you need to end on a high, serious high. You know, my paper is titled The Closer, you know, even though we're dealing with written submissions generally. You have to close with a bang. It is now time for you to take it home. Client is sitting there, and I agree with Tim. I try to write, I'm actually, some of what I'm saying to you is taken from a book which I hope to finish during the course of this year. I'm on advocacy. I used to speak about writing a book on advocacy with my friend, Ronnie Budusing, which is a book I would commend to you on the platform if you do not have it or know of it. You know, it's written about advocacy. Ronnie is a judge in Trinidad and Tobago, but we used to sit on the academic committee of the Council of Legal Education, which governs the law schools and so on throughout the region. And you know, I finally, I'm working on it, and there's reference to it in my little bio. It's called This Is My Courtroom, with emphasis on my, take from the perspective of judge, litigant, lawyer, you name it, but that's to come. But one of the points I'm making it is, there are times when the client is sitting beside you, hugging, just listening, hanging on to your every word. You have to speak in a way quite often where the client can understand, because at the end of the day, it is his or her case. You don't want to be saying things which necessarily going over the head of the client. Sometimes you have to use certain expressions which only the lawyers will understand, but you have to remedy that very quickly, as I do often. Even sometimes I'm on my feet, I'll just scribble on a paper and let the client know what this meant, or why I said this. Or even when I sit, I will just have a quick little discussion and say, I said this is how lawyers talk, but this is what it means. But you always try to write in a very user-friendly manner so that the public can understand, which is exactly how I'm writing this book, which will surprise some. So in your written submissions, in closing, you need to take it home. Just like Patrick Mahomes, you need to bring the touchdown. And just before I close, you will see on the previous slide, I refer to the late Johnny Cochran if you just might back up a bit. The written submission should end in such a way that the words constantly resonate in the minds of the adjudicators or tribunal. One can recall the late Johnny Cochran's immortal and highly effective refrain, "If it doesn't fit, you must acquit." In the celebrated O.J. Simpson trial, started approximately 30 years ago, 1994. Judge Ito was all on our TV screens. Before I go to the final slide, I want to share something quickly with you. Years ago, I was appearing in a criminal matter with trial murder case where a well-known gas station owner was unfortunately murdered. And the DPP himself appeared, predecessor to Jamaica's current DPP. I'm talking about, at the time, it was Mr. Ken Pantry, Queen's Counsel. And here I am before Justice McIntosh, one of the McIntoshes, and I'm trying, how do I convince his jury? And Johnny Cochran came to my mind when I'm about to do my closing. And this is I said, oh, it doesn't fit. How can I need a rhyme. And I said, somebody said something about gel. It's funny. I heard a lady talking something about gel. And I said, gel. She was talking about hair gel. I said, if it doesn't gel, throw it to hell. And I kept mulling it over. The hell part was a little iffy, but I said, what the hell? This is a murder case. I have to represent this man hard and fully. And got up, man, turned to the jury and smiling and said, the 4 members of the jury, if it doesn't gel, throw it to hell. That is what I want you to have. The facts do not gel. The judge looked at me and said, Mr. Wilkinson, if you say that one more time, you're the one who's going to hell, I will send you there personally. So you have to be careful of those pearls of wisdom, those little jargons, those tidbits. Tim said, careful with the jargon. But it's good to use day-to-day language, even though you're dealing with an educated tribunal, steeped in the law. Little day-to-day expressions can still be very effective, even in your written document. All right, so as we close, go back to the denouement resolution. There's a lot of resource material on this. Tim mentioned a few, and I'd indicated in this paper that he would do so because I'd seen in advance some of what you had written. I would commend to you something I read just recently. It's the Art of Written Submissions, and it was date stamped June 2022 by the Honorable Justice Glenn Martin, a senior judge from Queensland. Found it to be quite useful. If you Google it, it will come up on your screen. And I would respectfully submit that the legal practitioner, all of you, especially the younger ones at the bar, you should source as much material as possible, assist with honing your craft on written submissions. There's a lot more which could be said, but I think it's a good point to stop so that we can accommodate your question. And when I say we, Tim, I end by saying, whatever you're doing in terms of written submissions, whether it's an interlocutory matter, whether it's at the closing, you need to end with a bang, end on a high, just like the great Dr. the Honorable Usain St. Leo Bolt used to end those relay races at the Olympics and the World Championships. That's how you need to end, running through the tape on a high. I think that's just about it, Mr. Emmanuel. Thank you very much, ladies and gentlemen, for your patience and for providing us this platform to share this afternoon with you. And with my learned friend, Mr. Prudhoe, from whom, as I said, I knew I would have learned something. Thank you very much.
Thank you, Mr. Wilkinson. Casey, We now invite any questions from the attendees in the audience, as well as those joining us online. Thank you.
Well, perhaps I could just ask a question of those who've been able to attend. And obviously, I don't know who's listening, so I don't know how senior the people are who's listening. With the exception of Miss Lockhart, because I know the answer, how many of you have had the chance to go from the beginning to end and present on your own written submissions here in the TCI? Anyone? Well, I would encourage you to find a case that perhaps might even be below what you're doing with the people that you're working alongside in order for you to own the whole process. So I think it's important for you to be let loose on something like that, and not a plug for legal aid practitioners, but I'm one of the people who sits with His Lordship, Mr. Grucho, on that board, and we regularly get applications for civil legal aid that will provide for people the opportunity. So bug the people who you work for the opportunity to take those sorts of cases, because you will be able to plead them. I don't know if Mr. Wilkinson has anything to add to that, but it's really important that you get your hands around. Have a smaller case, it's your problem 100%. That's completely different to having the opportunity to ask more senior people, but it's your problem when it needs to be presented. And I really urge you to get into that mindset as quickly as you can. You can become quite a senior lawyer and never had to bear that particular responsibility. Avoid that if you can.
And just to comment on that, that's a very good point. Just to give another example, I always say to my juniors, and you can have juniors who are even older than you at the bar, you know, it's one of those curiosities of the legal profession. You must, I say to them, listen, give me a start. I know my style might be a bit different from yours. After a while, you work with certain persons, they know your style. I have a junior now. I will tell him, give me a start on the written submissions. And he knows what my style. He will look at some of my previous work. He will know what I'm expecting. It's always good to get a start and from a junior counsel involved in the matter, because it shows the other mind at work, and you can bring your experience to bear and quite often your greater knowledge, own those submissions and tidy up the paper. A good junior will give you such a great start that your work is really, really very shortened. You have to do very, very little, except just a little tweak here and a tweak there. And that is important. Going to the point that Tim just made, because I say to the junior lawyers, pretend that you are the only person on this case, that I am not here to argue it. I am not here to correct the submissions. And that was a very excellent example from Kissinger. You bring the best out of people that way, because when people know that you're there in the wings, they tend to have, I've seen it so often with counsel, they tend to have this approach to, Mr. Prudhoe is there, man. He will fix any mistakes I make and so on and so forth. The trick is try not to make the mistakes. Pretend as if what that document on which you're working is going to be the end product, and that you are the last bastion for the client. So it's good for you to get the experience from early, from start to finish, working on a matter, treating it as your own. If you appear, and I've had very, very good work with solicitors, even though, well, in Jamaica, we call them attorneys at law, but there are some lawyers who just practice clearly as solicitors, and they will do excellent drafting, but they will never appear. And I think that's an excellent bit of advice from Mr. Prudhoe.
You don't have to drop off the cliff. I view it as of taking the stabilizers away. So the first time that someone's name goes on a skeleton argument,
yes,
behind mine, the next time their name goes on the skeleton argument on their own, and they look at you really nervous. So, well, you're doing the appeal, so why would your name not be on the skeleton argument? And I
Yes.
call it constructive anxiety. So each time, tell me if I'm wrong, each time I think they've mastered whatever that is, I drop them deeper into the case.
Yes.
What's
Yes.
the point of not doing that?
Yes.
Why
Yes.
do you do this job if that isn't what you aspire to?
No, that's a very good point. And you develop persons that way and you get them the confidence so that sometimes, Tim, you can just say, you just go to court. I see we have someone on camera, Mr. Emmanuel, who probably wishes to ask a question.
Oh, right. I see. Akira has a question, I think.
Is it okay?
Yeah, hi.
Okay, brilliant. So I want to say thank you to Mr. Wilkinson and as well as Mr. Prudhoe. Both presentations were great food for thought, a great refresher for someone who's been at the bar as long as I have, but because I'm always in and out of practice, it's always helpful to have a refresher. But my question really is, how can we attract more talent into the civil litigation bar here in Turks and Caicos? Because even if you look at those that are participating in today's training session, they're the regular practitioners. And so whilst it's a helpful refresher outside of the Stanbrook Prudhoe group of young attorneys, we're still struggling to attract more talent to the civil litigation bar, whereas the commercial bar seems to be obviously where most of the wealth can be generated. And so it's really to Tim's presentation of how can we attract persons to push the bounds of the law to introduce those new areas that decisions have not yet been made in this territory.
Well, Tim, you know the jurisdiction a lot better than I do. I'll let you lead on this.
Well, it would be fair to acknowledge that I am not without controversy. But I actively hunt down pieces of law that I don't think have been yet properly formed in the TCI, and feels a little bit like we're sort of running out of those, which is exactly why I lead a semi-itinerant life and gladly do so. But to your wider point, Akira, I think there is a serious question mark about whether, in my opinion, whether 3 months supervised practice with no syllabus is really helping anybody. There's a more controversial issue about whether Turks and Caicos Islanders are helped at all by being eligible for an exemption from even that. And I think that aspect needs to be shaken up significantly. I'm not holding up as a gold standard the English process, but I know that the English process is not alone in having quite a lot longer time where people are trainees. And I would be in favor of that. Obviously, that requires, of necessity, the buy-in, as it were, of employers. But if you get the blend right for that year's pupillage, I don't think there's a lot of difference between what they would be doing if they were licensed to kill, as it were, after 3 months, or if it was after 12 months. And I know which type of lawyer is better trained.
That's a good point. The first thing is you have to look at the infrastructure and the formalities or the legal hurdles. What are the criteria for practicing in the first instance? So, I mean, I was being encouraged to apply for full membership of the bar in the Turks, and I might yet do so. I was given only a limited admission, but and that's on a person, and that's fine. But I gather in doing my due diligence that regardless of the wealth and the breadth of my experience and so on, and if I were to want to come and do civil matters to bolster your numbers, as you say, I might have to pursue a particular course for a few months. That might be the case. I'm still investigating it. But if that's the case, that's quite strange. But I understand rules are rules. So the infrastructure, the legal formalities, one thing. The second thing I would commend is the persons who become lawyers, residents, islanders, or even people who migrate to the country. How have they been trained? What is their background? When was the last time a survey been done to see where are the actual needs for lawyers? Do you need, because at one point, sometime in the last 1.5 years, I heard that there was really a dearth of criminal law practitioners, not civil. So I was a little surprised when you said it, but you know the territory better than I do, for sure. So if you have that kind of information, the authorities can implement a program aimed or geared at targeting these gaps or shortfalls, and put in place incentives to encourage practitioners to pursue civil practice as well. Because the next thing too is, when there are civil matters, how much publicity do they get? I am not certain how much is the reporting on these matters in your local media, for example, because quite often a lot of young lawyers or would-be lawyers, they read these things and they're attracted to these things, and these things can encourage them to become a part of that particular fraternity. So these are just some points, some food for thought in relation to your question. Thank you.
I would add, and if I could just recount the fact that I was pulling Mr. Wilkinson's leg about the fact that although there are these rules to get admitted here in the TCI, they certainly don't have a shortage of hoops that you have to jump through if you want to get admitted in Jamaica. So I think there are issues in all of these jurisdictions. And bless them, there are as many good lawyers in Jamaica as we all know of being there. I think there are some really serious challenges for the profession here. And although for almost as long as I've been at the bar here, we've spoken about amending the legal profession legislation, the training part certainly needs an overhaul.
No other question yet. I thought came to me earlier in relation to a point that Tim said or made in his presentation, on which I'd like to just speak briefly. The use of submitting a copy of your submissions to the court. So when you do your written submissions, in fact, there's a practice direction now in the Court of Appeal where you don't just submit a PDF version. Normally, the practice is when you file your written submissions, our presentation is about civil trials, but I give this as an example, and it's done in the Supreme Court as well in Jamaica, which is our first instance high court. So when you practice, when you are supposed to submit a PDF copy first. We normally send it by email, and then we deliver the hard copies. The court usually asks to have a word copy, and Tim is right. What it does, it allows a lot of sometimes cutting and pasting, because what the courts do, they will not say to you officially, but what they do, they use the Word document you submit, and quite often, if you have summarized the facts accurately, that saves the court time. They don't have to be either the judge, and some judges actually type their own judgments. They have secretaries to whom they will dictate, or they have judicial clerks. But some judges, I know one particular, like several judges in the Supreme Court, and at least one or two in the Court of Appeal, who like to type their own judgments, and they do it very effectively, and they will send it to others to proofread and so on. So when you send the Word version to them, it's easier to just cut and paste certain things, cases, so that you don't have to be writing over the name of the case and the citation all along and all of that. I will give you a quick anecdote. Years ago, I was less than 5 years at the bar, and we did a case, a personal injury case against one of my former teachers. And I was representing an insurance company, and the client won that case. A man who was seriously hurt when his bike, I would put it this way, collided with a motor truck, and I was representing the insurers who had insured the truck. And we won totally 100% finding on liability. And that's another thing too. You know, counsel, just as an aside, whenever you have a chance, as I say, a bad settlement is better than a pretty loss or any loss at all, because we had made an offer to give them the policy limit, but they didn't accept it. They wanted more and ended up getting absolutely zero. But after the case was done, a very curious thing happened, and I'm seeing the judge now. It was a very good judge who ended up on the Court of Appeal of Jamaica. He actually said, Mr. Wilkinson, the submissions you filed, and I had the help of my senior in the firm, but I largely did the case, Tim, from start to finish, as you articulated. The judge literally said, Mr. Wilkinson, I accepted literally almost all your submissions. What I'd like you to do to save me the trouble, I still find it funny to this day, to save me the trouble, just change up the heading and all of that, put judgment at the top, send it to me and I'll fix it off. I'll get it to my class and I'll fix it off. I still remember that vividly, and that's like 30 years ago. So it's come not full circle, but 30 years later, it is now entrenched in the system whereby the courts want a copy of your written submissions in a particular form so that they can use the material to save time. Thank you.
Perhaps there's no better place to end what we have to say on. If you get to a stage where the judge is asking you to write their judgment, I think you've really done your job. The fact that Mr. Wilkinson was being asked 30 years ago is a bit humbling to me, but I'm certainly very grateful for the opportunity to speak today and share some thoughts. It is a task that you can get better on, but you really do need, as soon as possible, to start practicing.
Thank you. All right, so just before Mr. Emmanuel closes, I'd like to extend congratulations to Mr. Prudhoe on his victory in the Privy Council, about which he spoke. I actually saw it earlier because I tend to monitor the senior courts very often. And if you were not called on, that is also a feather in your cap. Sometimes the law is not just quite clear, but it is because of the strength of the written submissions quite often. And that's a congratulations. And thank you to the audience for listening. And we truly appreciate it and look forward to seeing you some more. Thank you.
Thank you, Mr. Wilkinson, KC. On behalf of the Judicial Education Institute, we'd like to thank everyone who attended today. In particular, we'd like to thank our two presenters, Mr. Wilkinson, KC, and Mr. Tim Prudhoe, for your extensive and thorough presentations, and in particular, the wealth of resource materials that you've also provided, which is sure to be of use to the members of the bar. So we thank you for coming today. And without further ado, that's the end of our presentation. So thanks a lot, and thank you for coming.